Hello everyone and welcome back to your channel Lawpedia. So as promised, this will be part 2 of your judgments video of the year 2020, and in this particular video we'll be covering criminal law judgments given by the Supreme Court in the year 2020. So I hope आपने इससे पहले वाली वीडियो देख ली है, which is the part 1 in which we have already covered the Constitution Bench judgments of the year 2020 of the Supreme Court of India. So let's quickly get started with the criminal law judgments of 2020. So the first important judgment that you can read is Somasundaram versus the state represented by the Deputy Commissioner of Police. So this is one of the very important judgments given in the year 2020, which stated that uncorroborated testimony of accomplice cannot be the basis of conviction. So broadly, इस केस में कोर्ट ने हेल्ड किया था that for an accomplice to be believed, the material particulars of his testimony must be corroborated. It eventually upheld the convictions for the abduction and murder of Tamil Nadu politician and ex-MLA M.K. Balan in 2001. Now, to broadly understand कि ये judgment कहती क्या है, you need to be aware about certain terms. That's firstly, accomplice and what is a testimony. So, if you read the definition, accomplice basically is a person who knowingly, voluntarily or intentionally gives assistance to another in the commission of a particular crime. So basically accomplice एक ऐसा individual होता है who either abets the crime or is an accessory to the crime committed, and sometimes an accomplice is also equally liable as the principal offender. एक example से समझते हैं. Let's say A and B, two persons are there, and A has committed certain crime while B has given complete assistance to A in commission of the crime. So B will be an accomplice. So the judgment of 2020 stated that when we are considering the testimony of accomplice, it must be corroborated. That means it should be supported by other evidences as well. So the next important judgment of 2020 would be Rhea Chakraborty versus State of Bihar. In this particular case, court directed CBI probe in the Sushant Singh Rajput death case. So this was a very widely debated case. So I hope आप इसके बारे में तो well aware होंगे ही that court, while invoking the plenary jurisdiction under Article 142, the Supreme Court upheld the FIR registered by Bihar police and asked the Maharashtra police to hand over the evidence and assist the CBI in the case relating to the death of Bollywood actor Sushant Singh Rajput. The next important case that you can read is Ashoo Surendranath Tewari versus the Deputy Superintendent of Police. In this case, the fundamental aspect addressed was criminal prosecution on identical allegations will be discontinued if exoneration in departmental proceedings is on merits. Supreme Court ने कहा that in case of exoneration in departmental proceedings on merits and where the allegation is found to be not sustainable at all, the person was held innocent. Criminal prosecution on the same set of facts and circumstances cannot be allowed to continue. That means if in a departmental proceeding a person was found to be innocent and the allegation जो उस पे लगी थी were found to be not sustainable, a criminal prosecution cannot continue on the same set of facts and circumstances. These terms are important, that similar facts and circumstances पे फिर criminal prosecution sustain नहीं करेगा. So this was another judgment. The next important judgment is Abhilasha versus Parkash. So in this particular case, court stated that an unmarried Hindu daughter can claim maintenance from her father till she is married, relying on Section 20, subsection 3 of the Hindu Adoption and Maintenance Act 1957, provided she pleads and proves that she is unable to maintain herself, for enforcement of which right her application suit has to be under Section 20 of the Act. Basic theme क्या था इस judgment का? That Hindu unmarried daughter can claim maintenance from her father under Section 125 of CRPC. Next important judgment would be S. Kasi versus the state through Inspector of Police. Important aspect addressed would be extension of the limitation due to lockdown not applicable to the period of filing charge sheet under section 167 subsection 2 of Criminal Procedure Code. कोर्ट ने इस केस में हेल्ड किया that its suo motu extending the limitation and the lockdown restrictions of the government will not affect the right of an accused to seek default bail under section 167 subsection 2 of CRPC. While granting default bail to the accused, Supreme Court set aside the view of single judge of the High Court that lockdown restrictions should not give a right to an accused to pray for grant of default bail even though charge sheet has not been filed within the time prescribed under section 167 subsection 2 of CRPC. Now, if you read the provisions of section 167 subsection 2 of CRPC, you will understand that it contains certain express provisions for default bail. So, a nationwide lockdown cannot be equated with a period of emergency so as to justify the denial of bail to an accused. So, bail is a very important right and Supreme Court ने इस particular judgment में इसी को emphasize करते हुए ये कहा है that the extension of limitation due to lockdown will not be applicable in case of seeking default bail under section 167 subsection 2 of CRPC. So, in this particular case, though the High Court stated that the lockdown announced by the government is similar to proclamation of emergency and if emergency is declared under Article 358, rights under Article 19 are suspended and the right to life guaranteed under Article 21 is subject to restriction. However, the Supreme Court in its judgment made it clear that Section 167 of the CRPC gives due regard to personal liberty of a person. And Supreme Court stated that without submission of charge sheet within 60 days or 90 days as may be applicable, an accused cannot be detained by the police further. So, the provision of bail is a matter of not only statutory right but also a constitutional right guaranteed to the accused. And इस केस में सुप्रीम कोर्ट ने ये भी कहा that the fact that extending the limitation will impact section 167 subsection 2 is not right. And even during the lockdown, the charge sheet could have been filed before the magistrate and the investigating officer was not precluded from doing so within the stipulated time period. And court further stated that if we have to take the High Court's reasoning, then it's not compulsory for the police to produce the accused within 24 hours before the magistrate's court as well. That is stated by as per your section 57. However, this is not true. And section 57 and section 167 of the CRPC are supplementary to each other and ये recognize करते हैं right to personal liberty of a person as stated in our Indian Constitution. इस केस में कोर्ट ने broadly interpret की right to bail of a person को and how will that be affected by the lockdown restrictions imposed by the government in the year 2020. Now the next judgment that you can read is Subaid Ali versus the state of Assam, in which Supreme Court held that it is not necessary that before a person is convicted on the ground of common intention, he must be actively involved in the physical activity of assault. If the nature of evidence displays a pre-arranged plan and acting in concert pursuant to the plan, common intention can be inferred. It was a pretty simple judgment जो कि interpret करती है common intention while proving the crime of a person. And the main theme was active involvement in the commission of offense, not a precondition for common intention. Now the next important judgment that you can probably read is Tofan Singh versus State of Tamil Nadu. So इस case में main theme था officers authorized to investigate the NDPS cases are police officers and confessional statements made to them are not admissible. court by a majority ruled that the officers who are vested with the powers under Section 53 of the NDPS Act are police officers within the meaning of Section 25 of the Evidence Act 1872, and as a result of which any confessional statement made to them would be barred under the provisions of the Section 25 of the Evidence Act. As you all may be aware about, the confessional statements made to a police officer are not admissible. Therefore, they cannot be taken into account in order to convict an accused under NDPS Act. कोर्ट ने फर्दर ये स्टेट किया that a statement recorded under Section 67 of the NDPS Act cannot be used as a confessional statement in the trial of an offence under the Act. So, इस पर्टिकुलर केस में कोर्ट ने ब्रॉडली ये स्टेट किया है that those officers who are investigating the NDPS cases are also police officers. So, कोई भी ऐसी स्टेटमेंट जो उनको दी जाएगी will also be barred by the provision of Section 25 of your Indian Evidence Act. You can read this particular provision further. Now, the next important judgment that you can read is Arnab Manoranjan Goswami versus the state of Maharashtra, another very important judgment which was very much in news through the later part of 2020, whereby Supreme Court ordered the release of Arnab Goswami, the journalist. In its judgment, the top court said that the Bombay High Court in its verdict abdicated its constitutional duty as a protector of liberty by refusing to grant relief to Mr. Arnab Goswami. Court ने ये भी observe किया that it could not be held that Goswami had abetted the suicide of Anve Nayak, for which Mr. Goswami was arrested. And court ने यहाँ पे state किया that the doors of this court cannot be closed to a citizen who is able to establish prima facie that instrumentality of the state is being weaponized for using the force of criminal law. Now, the next judgment that we quickly move on to is Paramvir Singh Saini versus Baljit Singh. In this case, the court directed that all states and union territories to install CCTV cameras in all police stations and file a compliance affidavit within 6 weeks. So, इसमें important क्या है? इस judgment में Supreme Court ने direct किया the installation of CCTV cameras in all police stations. The top court also directed that the central government should install CCTV cameras at the offices of CBI, NIA, Enforcement Directorate, Narcotics Control Bureau, Department of Revenue Intelligence, Serious Fraud Investigation Office, and any other central agency office where interrogation of people is carried out. The court also in its judgment mandated that CCTV systems so installed must be equipped with night vision and must be necessarily consist of audio as well as video footage. So ये particular judgment होती है important इस regard में that Supreme Court directed the installation of CCTV cameras in various authorities जो कि responsible हैं for conducting of interrogation of people. Now, the next important judgment we move on to quickly is Amish Devgan versus Union of India. Main theme is merely referring to feelings of one community or group without any reference to any other community or group is not a hate speech. An aspect of hate speech was contested in this particular case. कोर्ट ने क्या स्टेट किया? Universal definition of hate speech remains difficult and incitement to violence was a key ingredients. The bench refused to quash the FIR registered against News 18 anchor Amish Devgan for using the term Lutera Chisi in one of his shows. The court granted interim protection against the arrest subject to his joining and cooperating with the investigation. So there was aspects of hate speech debated in this particular case by the Supreme Court of India. Quickly moving on to a last judgment that we need to discuss in brief will be Shilpa Mittal versus State of NCT of Delhi. इस particular case में main theme था offences prescribing maximum punishment of more than 7 years but not providing minimum sentences are not heinous offences but serious offences under the Juvenile Justice Act. कोर्ट ने इस केस में हेल्ड किया that only those offences which prescribe a minimum punishment of 7 years or more can be regarded as heinous offences under the Juvenile Justice Act. 7 years or more की punishment होगी, then only it can be regarded as heinous offences. Otherwise, it will be a serious offence. Offences not providing minimum sentence of 7 years cannot be treated as heinous offences. And offences जो कि prescribe करते हैं maximum sentence of more than 7 years but not providing any minimum sentence or providing minimum sentence of less than 7 years are not covered by section 2 subsection 33 of the act. And finally कोर्ट ने स्टेट किया कि ऐसे offences will be categorized as serious offences and not heinous offences as per the act. So I hope आपको ये clear हुआ है that the offences जो prescribe करते हैं maximum sentence of more than 7 years, let's say 10 years, 13 years, but कोई minimum sentence नहीं है और the minimum sentences of less than 7 years, those will not be categorized as heinous offences but will be categorized as serious offences. However, जो offences minimum sentence prescribe करते हैं of 7 years or more can be regarded as heinous offences. So with this, we come to the end of our video. I hope आपको criminal law judgments discussed in this case absolutely clear है. So again, अगर आपने subscribe नहीं किया है, so please subscribe to the channel and also click the bell icon so that you're notified whenever I'm uploading a video. And thank you so much for watching. For any legal help, please write down to me in the comment section down below. Till we have our next video of 2020 judgments, stay home, stay safe and keep learning.